Alexis Danielle Rapp versus Christopher George Rapp.
Good morning, Your Honors.
Good morning.
Jay Longmire, I'm out of Sumner County. Pleasure to be back before you. It was pre-COVID, I think, the last time I had the pleasure. So good to be back. Your Honor, please, I would like to try to save 5 minutes in case there's rebuttal of merit to share with the court. Your Honors, this is a relocation case. I know you're familiar with that. And as such, it's up before the court under an abuse of discretion standard. And the short argument for that, frankly, is that we believe that the trial court overemphasized the father's involvement, underemphasized the mother's involvement, and didn't focus as strongly as she should have in terms of the best interest of this child. We are dealing with one child. We're dealing with a relocation of some distance from Springfield to Richland, Washington. And part of the struggle I had in the advocacy role in this case was I thought that was really weighing on the court's mind in terms of the distance. And while we had some banter about that, in terms of that is certainly a consideration the court can and should consider, it shouldn't have the emphasis from my perspective that I thought it had in this case, because it's not really part of the recipe items that you find in the statutes. I know we have the boilerplate that the court can rely on whatever court feels is appropriate, and that probably is what the court did, but it just seemed to be a real emphasis on Her Honor's ruling that it was a 2,200-mile distance between Springfield and Richland. But we're talking about a 4-year-old at trial, almost 6 today, divorced in 20. This case happened in 23 in terms of the trial court presentation. The parenting plan that the court had entered upon the agreed divorce was 249-116 in favor of the mother, who is also the PRP. The de novo review that I'm bound to in this process, I would suggest to the court that 2 of the items in that analysis are what should have the focus, that being an incorrect legal standard, I think, was applied to Her Honor's ruling in terms of the evidence associated with the just original parenting plan, not the relocation statute standards. I think it was Section 8, where she required, or required probably not the correct word, where she referenced in her order that it was not a preponderance of the evidence that was shown regarding the inappropriate touching, frankly, between...
Counsel, let me ask you about that. So the trial judge here, there's allegations involving abuse with a stepsister in this case.
Yes, sir.
And the trial judge determined that, if I'm following correctly, the trial judge decided by preponderance of the evidence, I don't think it happened, is what she's saying.
Yes, sir.
If that's correct, then why is it error for the trial judge not to put weight on the abuse or the alleged abuse in this case? I mean, it seems like if the trial judge says, I don't think it occurred, then it seems pretty sensible to not put any weight on the abuse as a aspect suggesting that relocation is warranted. And if she doesn't think it happened, why is she supposed to put weight on it?
Well, I don't, that's where perhaps we would differ in that standard. You know, when you say a preponderance of the evidence, we know as advocates of the system, that means that the proof reaches a favor to one side barely, or just enough to tip the scale, so to speak. When she says that, it's almost like, from my perspective, she was evaluating whether or not the evidence that was basically all the DCS stuff reached that level to consider it, as opposed to what the statute says, which is just evidence. So I think it's a much higher burden, frankly, for the proponent of that evidence if they have to show by preponderance of the evidence something like that occurred versus just evidence if it occurred. Now I certainly appreciate the reality of the court's question, and that is, if she had just said the evidence doesn't sway me, then I guess I wouldn't even be making that statement. And normally I don't have an opportunity to be before this court on an abuse of discretion alleging an incorrect legal standard. That's a little bit of an outlier for me.
Does that mean that, under the argument you're making, does that mean that if there's any allegation, any evidence, even if it's extraordinarily weak evidence, that it's error for the trial judge not to consider it as a basis supporting relocation?
I think so. I think because it's a totality. You know, as the court's opinions have repeatedly said, it's not just a road evaluation where we're keeping score. Which on that note, I might add, I find it rather unusual that of all the factors she considered the appropriate ones, the mother was not persuasive on any of them. And that's pretty unusual considering the facts, in my view, of what this routine was like for this particular child. So with that in mind, Your Honor,
So what I think I hear you saying is that even if the judge doesn't believe it happened, he has to consider the allegation in his totality of the circumstances evaluation of this situation?
maybe not to that extreme because unlike Your Honor's evaluation, I don't think her ruling is it didn't happen. I thought her ruling was more that by a preponderance of the evidence, it didn't happen. But there was only that evidence in the record. And so I do think, Your Honor, that when you're evaluating that factor under the other statute, it just says evidence, and so it should have been evaluated as to whether it was appropriate to consider in this totality evaluation.
Wasn't there some evidence here that it was an accident? That the contact was accidental rather than deliberate? And I'm not saying who's right or wrong in terms of that, but isn't there some evidence that was presented on?
That's the way the interviewer, if you look at the tape of the interviewer, and this may be tactic, I'm not here to criticize the interview process of DCS, but she asked it as a question, was it an accident? To which the child said yes, as opposed to the child saying it was an accident, because the version that child shared with his mother is much different than the version the child said with the interviewer.
Doesn't the trial judge though get to make that determination, totally, having heard that? And I mean, she totally does. I agree with that. I guess my focus is whether or not her inclusion of the word preponderance of the evidence changed the standard from which she looked at it in terms of whether she was going to consider it. But I guess in practical sense, if the court did not think it happened and dismissed it, it would be the same result because that factor didn't favor the mother either. And that wasn't the emphasis of this lawsuit either. That occurred, and of course there was certainly some discussion about motivations and timing and all that, but that was never the way it was presented to this court, as this is such a bad, or this happened to the point that these children shouldn't be together, and consequently the relocation should be allowed. This was brought really on the basis of the involvement of the child and his routine in the daycare system with the mother's work schedule and the father's minimal contacts and minimal involvements in this child's life. Counsel, the work schedule here, if I'm following correctly, mother's current work schedule at the time here at the trial is mother works essentially 7 straight days, and then she has 7 days. That's right,
7 to 5. I think.
And then if relocated to Washington State, the schedule would be a more typical work day,
40 hours, no weekends. Yes, sir.
Why is so? A lot of your argumentation relates to she'll be able to be more involved in school activities. Aren't there some advantages of sort of the 7 days on, 7 days off in terms of being involved in school activities, in terms of the parent being able to, if you've got a full week off, you can engage with the kid in a lot of ways that you can't on a 9 to 5 job. That
is my argument with the proposed parenting plan, that it gives the father blocks of times to have more meaningful durational periods with his son. So it's the same argument. So I don't dismiss that, but I think that the idea was when she's on and she's doing her performance, this child was basically in not to demean preschool, it's important in every child's development, but a daycare situation for 10 hours a day. And the father's activities, the court really emphasized this coaching t-ball. That was one season. And it's an important factor. Again, I'm not critiquing the action, but the court seemed to think how the father was so involved in this parenting schedule that, and the focus especially on the section that deals with the relocating parent and child's improvement emotional benefit is the point the court didn't say anything about. She just talked about the logistics of travel. So is it a long travel? Sure. This child has done it consistently for all of his life. When his mother goes to Washington State without a complaint, there's no proof in the record it was a negative, but the court seemed to think that was imposing on this young child. So in essence, I guess it's the court's, our view, respectfully to the trial court, the court's over-assessment of the father's activities when he didn't even follow never actually exercise the time he was allotted in the plan. It was less than that without any dispute in the record. We ask the court to consider that factor as well as the brief, rely upon our brief in your Honor's decision. Thank you for the opportunity to address the court, and I'll be back in the sense of the 5 minutes that I said.
Thank you.
Yes, sir. Thank you, Your Honor.
Morning, judges. I'm at please the court, Attorney Rhett Roach. I represent the appellee in this case, the father. I do want to start with the standard of review here under Armbruster versus Armbruster, which is cited on page 15 of the appellee's brief. It states, determining the details of parenting arrangements, specifically parenting arrangements, such as a parental relocation case, is particularly within the broad discretion of the trial court. As such, the high burden of the appellant in a parental arrangement case in the Court of Appeals is the abuse of discretion standard. And Canada versus Canada delves in further to that, which is cited on page 15 and 16 of the appellee's brief, which state that the trial court only abuses its discretion when it implies an incorrect legal standard, reaches an illogical result, resolves the case on a clearly erroneous assessment of the evidence, or relies on evidence that causes injustice. Here, what the trial court did in the ruling is it applied the appropriate legal standard under 36.6.108, and specifically looking at the factors enumerated under 36.6.108A2, those 8 factors. It reached a logical conclusion by keeping in mind the best interest of these parties' minor child, not the best interest of the parties, but the best interest of the parties' minor child. It resolved the case on a clear and correct assessment of the evidence, and it upheld justice. I do want to spend a little bit of my time responding to the appellant's attorney's opening. And interestingly, Mr. Longmire talks about how there was an overemphasis on the distance, the geographical distance which the mother was moving to Washington State. As the memorandum and the order states, it is 2,200 miles away. The court has to consider that. And the court has to consider that because of the feasibility element under 36.6.108A2, which talks about the feasibility, if the parent is allowed to relocate, the feasibility of this child to maintain the relationship with both parents, specifically the non-relocating parent. The mother tendered a proposed parenting plan at the trial court, which had the minor child making this cross-country trip 18 times in a year. This cross-country trip, which testimony showed, is two-plus hour flights, not including layovers, not including the child's traveling to the airport, traveling from the airport, any type of delays. And the court did consider that and put weight on that, as the court should have. And as far as the DCS investigation, I don't want to touch too much into this, but the trial court reviewed all of this evidence in chambers. It was reviewed, it was considered, and after that consideration of the trial court, the court did not put much weight on it because of what the DCS result was, which nothing was substantiated. So I'm not sure I'm personally persuaded on the argument that the preponderance of the evidence was the incorrect legal standard. In fact, the preponderance of the evidence standard is the lowest standard that we have.
Counsel, one of the arguments in this case relates to support, and circumstances come up. You know, somebody has to work late, somebody has an injury in this case, for example, or need assistance. In terms of the evidence here, it seems like mother regularly has to turn to her parents to help with the child in those types of circumstances. In digging into the record here, what are we going to see in terms of father's availability, willingness to help out in those types of circumstances? And is the record going to reflect that father essentially says, yeah, I can't help, I'm not available, or is this a circumstance where mother is turning preferentially to her parents over father?
The record will reflect that the father steps up in each and every time he is asked to step up. There was a lot of testimony on that exact subject. The mother had an ankle injury or a leg injury. The father stepped up. The mother has to work late. The father continually steps up to take that court-ordered time, that is the mother's time. The father has no problem in helping out the mother during her court-ordered time when he is asked. There was one instance in the record where the father was asked to help. The father was at his parents' residence. The father's father had a illness, and because of COVID, there was a COVID scare. He couldn't help that one instance. That's what the record will reflect. But each and every time, other than that, the record will reflect that the father steps up when asked.
And did he also exercise his visitation privileges under the plan that was in effect?
So they informally modify their plan. Without the court's orders, he got some time that he wasn't supposed to get. She got some time that she wasn't supposed to get, which in the world of co-parenting is a good thing. So there are times that he missed his days, but there are times that he exercised days that were not his.
When mother, who I understand kept a calendar on these things, when mother totaled up the days that father didn't exercise his rights, did she offset days when he did and it wasn't his time?
The calendar I remember that was presented to the court was the times that the father did not exercise his time. It was not the times that the father exercised time that was not his.
It didn't include or offset that time.
That's
okay.
correct. I do want to note that opposing counsel makes an interesting argument here, in that he finds it peculiar that not one factor under 36.6.108A2 weighed in the mother's favor. Well, that's because the evidence simply wasn't there. It was overwhelmingly that this relocation, that the mother's proposed relocation, was not in the best interest of this minor child. Therefore, because of that overwhelming evidence, not one factor weighed in the mother's favor for relocation. I will state too, there is, back to the feasibility argument, opposing counsel made a suggestion to Judge Usman's question about, isn't it better to be engaged in school if you have these 7 blocks days of time? And opposing counsel's argument was, well, that's what was our argument in court. We had 2 longer blocks of time that the father would receive during the summer if this relocation was appropriate. But there's a frequency argument there, right? It's not the father doesn't see the child for 1 week. We're talking about 2 months at a time that the father would not see the minor child. So because of that lack of frequency, it jeopardizes the minor child and the father's relationship, and it's not as feasible to maintain that relationship.
What about the fact that Mr. Rapp was behind on child support and some other medical payments that he was supposed to make?
Yes.
The court didn't seem to be bothered by that in terms of relocation.
Well, I think that the court was bothered by that in that the mother had the record of every penny that the father had paid. The father had no disputable evidence in court that day to say, yes, I am behind on child support payments, or I'm not behind on child support payments. And the court said, you need to get caught up and you need to pay immediately. That was the proper remedy for the hospital
Does that
bills.
play into whether, to relocation?
I don't think it does. And I think to your financial point, the mother made an argument about the financial factor that the minor child's financial would have more financial freedom if the child was able to move to Washington State. And she made this argument that her employment would increase by $15,000. And the court did not buy that argument. Whether the employment would increase by $15,000 or not, if you put that on the scale of is it in the best interest of the minor child, it's so minimal compared to the relationship that you would jeopardize between this minor child and the father. That is all I have if you have no further questions.
Counsel, I have a question about the attorney's fees. You noted attorney's fees in your brief.
Yes.
What is it that's necessary for you to show to be entitled to attorney's fees? And have you made that showing in your argumentation?
Yeah, I think that we would turn to Tennessee Code Annotated 36-5101, which states that specifically it allows an award of reasonable attorney's fees incurred on appeal. There are numerous cases that have come to the Court of Appeals in which attorney's fees have been awarded to the appellee. And essentially our argument here is the Brooks versus Brooks argument that is cited on page 27 of the appellee's brief, which states that essentially this father has incurred numerous attorney's fees in a case where on trial court it was overwhelmingly the mother's relocation was denied, and yet an appeal was filed, which I understand the mother has an appeal as of a right, but we believe that this appeal is meritless, and it's without merit, and because it is required that the father, if he wants to continue this action, defend this appeal, he's had to incur numerous attorney's fees for defending this meritless, baseless appeal action. And that's why we are requesting for really this case to be remanded to the trial court for the sole reason to determine whether the father should be awarded a reasonable attorney fees that has been incurred on appeal.
Thank you.
Thank you.
I think it's precisely the point of this appeal when counsel tells the court that he can't maintain the same relationship, because it's the exact words that the trial court used in her decision on page 7 when talking about subsection C on the factors, that the court cannot see how the father will be able to maintain the same relationship, emphasizing the word same, he has now with a child upon a move of over 2,000 miles away from his current home. That was my point. If you move to Memphis, you're not going to have the same relationship. It's not practical. You can't go coach T-ball on a Tuesday when you're 3 hours away. So moving 2,000 miles versus 200 miles, I don't think that's what the statute directs, because what it says is preserving the relationship. That's a crucial semantic distinction, preserving the relationship versus the same relationship, because it's impossible on any relocation case.
Why is it wrong for the trial judge to think about, this is a young child we're talking about here.
Yes, sir.
And you're talking about, my understanding from the record is there's not a direct flight. You're talking about that there's essentially a day of travel and doing it 18 times as a young child. Why isn't that a legitimate consideration for the trial court judge to take on? And I know you're saying Memphis versus Washington, and it's going to change either way, but
Yes, sir.
and isn't that a pretty reasonable consideration to say you're putting a young kid you're having a lot of travel time with a young child here?
Judge, if there was proof to that effect, that it was a negative for the child, yes, sir, I would agree with you. Zero proof of that. Child does it twice a year now with his mother at ages 2, 3, and 4. And the child being 4 has spent 3 years of his life as separate standards or separate homes. And so that's normal for him. So when you talk about shouldn't she consider that, well, yes, but you know what the record does show is the father never complained one time that it was a lot of travel for the son to go make the trip, period. And the mother testified that he's a great traveler and that the breaks involved actually help a smaller child. So I just think the court obviously focused on this same relationship in relationship to the distance, which I do not think is the way the law directs us, the statutes direct us. When the court asked about whether the father steps up every time, the answer to that is no, sir, he does not. He doesn't. And the chart, which was not only adopted and used by the father, approved by the father, and stated by the father it was accurate, is every day of parenting. And it's 98 days on the last 2 years. Of course, the first year was a fractured year because the divorce happened, I think, in June of 20, et cetera. So when you talk about D step up, when he had when COVID shut down the daycare, which was the first episode, the father said he wasn't going to take him. The testimony's in conflict because he says he told the mothers because his father's medical health. My client testified, he never told me that. So the mother came in for that 3 weeks, I think. And then the second major time was the ankle injury. The father took the child the day of the event because the mother was in the ER and had surgery the next day. And then guess what? The father, maternal grandfather, had to come to Nashville, seems aggressive, came to Nashville to accept his role and stayed for 4 weeks. And no extra time was ever asked of the father because he never asks for more time. And I think that's a true distinction in this record.
Does the record reflect whether mother asked him or whether she preferentially went to her father?
I don't think she ever preferentially went. I think that was a standard because it happened. But when she would make every accommodation in the record, you'll find many parts where she makes every accommodation to him to accommodate his requests. And he still doesn't exercise all the parenting time. You remember, I thought it was a pretty big part of the facts. This father drove by the daycare at 3 o'clock every day. And instead of stopping and picking up the child to take him home for the mother to pick him up at his home at 6, left him at daycare. And his answer to that when I pressed him about it was simply, well, it never really occurred to me.
Well, those weren't his days, right?
Weren't his days. But a father who's trying to be, as Her Honor said, found that he is in the day-to-day activities of the child's life, that defies that statement because he never even thought about doing that. So, thank you, Your Honors, for your attention to this, and I appreciate again the opportunity to appear before you.
Thank you very much. Thank you both. Would you call the next case, please?
Laura Michael Hudson versus Stephen Brian Hudson.